Hello, and welcome to Google Eyes and Big Brother Lies, Data, Privacy, and Algorithmic Justice. My name is Colin Starger. I am pleased to be your moderator for today's event. I'm a professor of law at the University of Baltimore School of Law and director of the Legal, Data, and Design Clinic. And today's webinar is the latest in a series of webinars, the Law in Focus series, that's organized by our communications director, Chris Stutz. And we'd like to thank her very much for all of the hard work she does in organizing all of the sessions, including today's. We'd also like to remind you that next April 14th is another what should be excellent webinar on the school to prison pipeline. So mark your calendars for that. But today's webinar comes almost exactly a year after we entered lockdown. During that time, the presence of technology has gone far beyond its previous levels. We all know just how part of our lives it is, and we have come to rely upon it in really profound ways. And while we are relying on tech, tech is watching us. And today we ask, what are the implications of that? Is it a good or bad thing, and what can we do about it? And in that year since lockdown began, we've also seen tremendous social upheaval and political change. Just today, the police officer who killed George Floyd is on trial. We have a new president in the White House. We have a vaccine that has rolled out. We seem to be at a real inflection point. And perhaps now is really the time to ask, will 2021 be the year that Americans take control of their data privacy? Will we be able to understand the meaning of justice in the digital age? Or in other words, what is digital justice? To explore these questions and others, we have a distinguished panel, and I'm very happy to introduce them to you now. The first person I'd like to introduce you to is Professor Michelle Gilman. Michelle Gilman is the Venable Professor of Law at UB Law. She directs the Saul Ewing Civil Advocacy Clinic, in which student attorneys represent individuals and community groups in a wide array of civil litigation and law reform projects. In 2019 to 20, Michelle was a faculty fellow at Data and Society, researching the impacts of data-centric technologies and privacy law on low-income communities. Welcome, Michelle. Our next panelist is Natalian Conde. She is the founding CEO of AI for the People, a nonprofit communications agency whose mission is to eliminate the underrepresentation of Black professionals in the American technology sector by 2030. Prior to founding that organization, Conde worked on federal legislation that included the Algorithmic Accountability Act, the Deep Fakes Accountability Act, and the No Biometric Barriers to Housing. She writes widely on race and technology and speaks at conferences across the world. She is currently a fellow at the Digital Civil Society Lab at Stanford and an affiliate at the Berkman Klein Center of Internet and Society at Harvard. Welcome, Natali. And last but not least, we have Matthew Steubenberg. Matthew is a graduate of Maryland Law School and has created a number of legal tech innovations, including MD Expungement, which automates the expungement process of criminal convictions in Maryland, and the Clue database, which through web scraping has replicated the entire Maryland judiciary case search database. That's something that our clinic uses a lot and many people use throughout Maryland. He now works at Harvard Law School's Access to Justice Lab, where he runs randomized control trials on access to justice interventions for legal groups, for legal aid groups and courts. And so welcome, Matthew. So before we get to the questions, I just want to recognize that the one strange feature of these webinars is that we can't see any of you. So we see our faces, but we don't see your faces. We'd love to see you. But there is the chat function. So I invite folks to just say hi in the chat if they want to, announce yourselves, just so we know that there's people there. We're not speaking to an empty room. And of course, you can ask questions in the chat but probably a better place to ask questions is in the Q&A box that should be at the bottom of your screen. We'll do our very best to monitor those and get to as many of those as we can during the course of the webinar. So with that introduction, come to a conclusion. Let's turn to the first question. And the first question I wanted to ask you is if you consider yourself a techno-optimist or techno-booster, or let's say a techno-pessimist or techno-skeptic when it comes to how technology and law intersects, and why? Why do you see the glass as half empty or half full? Michelle, why don't we start with you?
Thanks, Colin. I would put myself in the techno-pessimist category. Of course, there are all sorts of technologies that exist that improve our quality of life, our well-being, our health. I'm not worried about those. I applaud those. What I'm worried about is this huge ecosystem of big data in which our personal data is being scraped, aggregated, analyzed, and sold in ways that we don't consent to. And these big data systems are particularly harmful to low income and marginalized communities, which are the communities my students and I represent in the Civil Advocacy Clinic. I see those technologies and the digital profiling they do of people increasingly serving as gatekeepers to people's ability to access housing, employment, education, healthcare, and poor people are often excluded on the basis of their digital profiles. And sometimes they're even targeted on the basis of digital profiles, such as by predatory lenders and so forth. And poor people are also surveyed by technology more than middle class and wealthier Americans. And we don't have right now adequate laws protecting against those harms. So put me in the pessimist category.
Thanks, Michelle. How about you, Natali?
So I'm probably a bit of both, with a bias towards fear. And the reason that I would say that is when I think about how technology and the law intersect, I'm thinking specifically in two places. Policymakers who are, as Professor Gillum said, really not providing legislation that's protecting us, certainly not on the federal level. We're seeing more of that on the city and state level, but then also the judiciary. So my kind of entry point to this is really trying to explain that technologies themselves are agnostic or can be agnostic. But if we're speaking about the law, and even that's contested, and we can go into that, but speaking about the law specifically, I'm thinking about deployment and governance. And from a criminal perspective, specifically interested in how advanced technological systems, specifically biometrics, so facial recognition, gait recognition, those types of technologies are being used as if police forces then have probable cause for arrest. Once we get to policing technology, who gets arrested and how, this is also a racialized question, right? If we're looking at wrongful arrest, we're typically speaking about low income Black and brown folks who ironically are the same people that Professor Gillum is representing in her clinic. So it's not just that housing, employment, and other issues of life or other resources are being denied. There is this increased probability of arrest. And so I'd say that makes me extremely pessimistic. But what makes me hopeful, actually, in terms of technology and law, are the people on the public interest bench. And the reason that those people really interest me, and those people are people that I rely on as a technologist, is that if you are a public interest lawyer, you are probably on the front lines of seeing these issues that algorithmic recommendation systems create for poor and disenfranchised people. And you have way more information just in terms of taking cases than some of the judges that you're coming in front of. And so kind of both. If we can get it right in the public interest space, and then we can get some good case law, and hopefully that will push strong city, state, and federal protections.
Excellent, thank you. I definitely agree with the idea that technology is arguably agnostic, but its application is where the rubber is going to meet the road. So Matthew, I'm going to put the question to you as well, and I'm just going to let the folks out there know that at the after Matthew has finished speaking, we're going to launch a quick poll and ask everybody else how they feel. Are they techno-optimists or techno-pessimists? But first, let's hear from you, Matthew.
Yeah, so when it comes to how lawyers will fare in the future with legal tech, I tend to be more of a pessimist. But I think for non-lawyers, professionals as a whole, I'm actually a techno-optimist. I think we are at the very start of kind of this legal tech revolution, and we're working through a lot of these really complicated kind of bugs that need to be worked out. And you can kind of analogize it to when cars first entered the scene, right? People just kind of threw cars onto the road, and there were all kinds of issues no one had thought about. You have to build roads and sidewalks, and what happens when it hits somebody or there's a car crash. All of these things need to be worked out, but cars are still here. All of these technologies are already out of the bag, and they're going to remain. And I think rather than trying to try to fight them or put them back into the bag, the best course especially for nonprofit legal aid people, is to try to work to make the technology as fair and as equitable as possible. And I think these technologies have a lot of hope to actually decrease the costs in a lot of areas and actually provide more justice and provide more oversight than we've ever had in the history of the legal field. And so while I think we're at the very start of this and there's going to be lots of bumps along the way, I think ultimately this technology is going to be beneficial for the population as a whole.
Excellent. Now with that, Chris, if you could launch the poll, that'd be great. And I love the idea that you can't put the genie back in the bottle. And I also love the idea that we need to take control of it. I guess that makes, I'm sure there's other people, but you'll forgive the anachronistic analogy. But if this is like fixing the bugs in cars, we're all the Ralph Naders of the current system, trying to make things work and make things safe. So I can see the poll, but it tells me I'm not allowed to vote, and I guess the panelists aren't allowed to vote either. So Chris, if you want to just let us know when the results are through or how that works. I don't think I can control it. All right, there we go. So it's up on the screen. It looks like there was a not sure option. We let the not sure option go. Well, we'll try and convince those folks to come over, but we're a slightly more pessimistic group as a whole, which is unsurprising. And I'm also unsurprised at the excellent sort of nuance that we've introduced to the question already. But why don't we try to talk to some brass tacks? So for the pessimists, starting pessimist, everybody expressed a little bit of both, but Michelle, let's start with you. What are some of the particular misuses of data or technology that you have studied and worry about in your practice? And what are some things that you think people might not know about in this regard, but should?
Sure. Here is where some examples from my actual clinic docket might be really helpful. Recently, the clinic has been representing a family facing eviction for failure to pay rent. And the reason they are behind on rent is because the father of the family lost work due to the public health crisis during the pandemic. And we have some defenses to the case, but regardless of whether we ultimately win or lose, the mere fact that a failure to pay rent action was filed against this family has been scraped by tenant screening companies that create digital profiles of pretty much everyone. And so this family wants or needs to move, or if they ultimately are evicted, this case will follow them forever, and in the eyes of future landlords, make them less desirable tenants. I'll give one more example. We had a case in the clinic where we represented an elderly and disabled woman whose home health care hours under the Medicaid program were cut significantly. And we couldn't figure out why. She was getting sicker, not better, which was very sad. And we're calling the agency and the social workers and trying to figure out what is going on here. And it wasn't until we were at a hearing before an administrative law judge that it became clear that the reason her hours were cut were due in part to an algorithm that the state had adopted. And at the hearing, there was no one from the state who could explain to us, what is the algorithm measuring? What data gets fed into it? How does it weigh the different factors? And my student attorney looks at me with panic in her eyes. She was doing an amazing job, but how do you cross-examine an algorithm? A lot of these algorithmic automated decision-making systems operate invisibly. People don't know they're out there and being acted upon by them. And so that, as a lawyer, can make it very hard to challenge them. So hopefully those examples just give you a taste, both on the public side and on the private side, what our low-income clients are facing every day. And they're usually entangled in multiple of these systems, not just one at a time. It's really a web of automated decision-making systems.
Thanks for those very specific examples, Michelle. And Mutali, I wonder if you can provide perhaps some specific examples on the criminal side, since we've heard some excellent examples from the civil side that demonstrate some of the problems that concern you.
Yeah, sure. So my nonprofit AI for the People, we're part of a global campaign with Amnesty International around banning government use of facial recognition technologies across the world. So one of the case sites is New York City, where I'm based. And that's really coming from a number of cases here in the US where police forces have used facial recognition technology to identify crime suspects. So the way that works is you could be anywhere. In the two cases that I'm giving, they're actually in retail stores. So one of the things that you don't understand is that when we go into stores, we're being followed by cameras. Most of those stores then share those images with local police forces. And that's what happened in the case of Najir Peters in Woodbridge, New Jersey. And he was identified as being in a picture in a store where somebody committed a robbery. That picture was then fed through their facial recognition system, and a positive match came back for Mr. Peters. The problem was Mr. Peters was actually 30 miles away at the time. And it was proven that he was 30 miles away because he was live streaming from his phone, and he was showing how he was having this amazing time with friends and family. But because facial recognition has a 40% error rate, he'd been misidentified by the system and therefore criminalized. Despite this, he was arrested. He then went into the criminal justice system where he was kept for 10 days because he couldn't make bail. And this really gets to what Professor Gillum is saying when poor people and marginalized people are caught in multiple different systems. So spends 10 days in jail, comes out, and then is able to get a lawyer, and they actually have an active case. The second case, which is shockingly similar, is Robert Williams, who in Detroit was accused of stealing jewelry. Same exact thing. The store cameras are given to the police. The police say that they have probable cause for arrest, but beyond, in this particular case, positive identification of a suspect. They then go to Mr. Williams's home and arrest Mr. Williams in front of his young child and family. The only problem is he hadn't been in this area of Detroit for over 5 years, and then was able to prove through his own digital photographs, because we're taking pictures of wherever we go, we're uploading these to social media. We're also then providing geolocation data. We think to the insurrection, the way many of these people are being caught is that they're telling the story of their lives on their social media feeds. And after 30 hours of questioning, he has the kind of wherewithal to say, let me see the picture. You say you have a picture of me stealing these watches. And when they show the picture, it's a Black person, but it's a different Black person. And he has been misidentified by this system. That case is currently currently the ACLU of Michigan have Mr. Williams's case, and they're now being litigated. But the issue that is going to arise is one that Professor Gillum spoke to. Because of IP laws, we don't know how those algorithms are making those identifications. And so, for people who are interested, Rebecca Wexler over at Berkeley Law wrote a great paper in 2017 called Trade Secrets. Because if we don't know how the decision is being made, then how do lawyers or legal practitioners prove harm? And if we don't know how to prove harm, then how can we litigate against? And the last thing that I'll say is that this question has actually been presented in Lomas v. the state of Wisconsin, where instead of facial recognition, it was a sentencing algorithm that was at play. But this sentence in the Lomas is allegedly the getaway driver for a crime, and when he goes to sentence, which was a violation of parole, when he goes to sentence, gets 6 years. And in the sentencing memo, the judge says one of the ways by which this determination was made was using this particular algorithm. So the case then goes to appeal, but at appeal, the Supreme Court of Wisconsin really rejects Lomas's claim and says that he would have got the 6 years otherwise. But the argument that's put forward in his defense is that he was denied due process. So these aren't just, bad robots or machines going crazy. These are people's individual rights being violated. And then on top of individual rights, there's somebody who is a justice advocate. I'm interested in algorithmic justice, the collective rights of Black and Brown people, because it's creating this record, this incorrect record, that we are more, which reinforces this idea that we are much more dangerous, that we're much more likely to be criminalized and committing crime. And it's really a bad algorithm. And so I write about this really widely, and I wrote a piece for the Harvard Kennedy School African American Policy Review around criminal use of algorithms, and they loved it. Then Harvard Business Review asked me to write a piece, and I really wanted to call it "Your Algorithm is an Asshole," but the good people at Harvard unfortunately didn't allow me to use that title. But that's what it feels like. Like, this is somebody who is acting in the worst possible will towards you and telling you that the decision is correct because it's quote unquote science.
Well, we won't beep you out on this webinar, and I would invite you, as well as the other panelists, to post into the chat the links to any of your own articles or to articles by other scholars or journalists that you think folks in the audience might appreciate. Thank you for those very specific examples. Of course, we see a little bit of some of the double-edged sword of technology in those examples, because although bad facial recognition algorithms implicated people, there was also some tech and geolocation that helped a little bit exonerate, but that goes to show the complexity of some of these questions. And Matthew, perhaps you can, as the resident optimist, you can give us some examples of ways in which you think there have been creative uses of data or technology to advance the cause of law and justice.
Yeah, so those are all fantastic examples of kind of where technology has gone a little astray here. When it comes to open data, I think that's one of the big pieces that kind of is very much a double-edged sword. So open data, all this court data that we've been able to scrape and put into a database, has allowed kind of do-gooders to be able to find police misconduct with the Gun Trace Task Force. They've been able to identify attorneys that are kind of filing frivolous lawsuits. They've been able to identify kind of a myriad of issues that wouldn't have been possible looking at a single case by single case. And because we have access to all this data and on such a quick turnaround time, you can do some really interesting things. You can get a window of how many people are being locked up on certain amounts of bail at any amount of time, and you can use that information to try to bail people out or argue cases that this person has not been able to afford a small amount of bail, and they've been locked up for a long time, and that's not fair. Some of these things would have been very difficult without access to a lot of this open data, and that's just on the do-gooder side. Another do-gooder example is with MD expungement. Because we have access to all this data, we've been able to automate the expungement process, where normally you'd be able to help a handful of people. It's very time consuming. Now you can help hundreds of people in a day, and it becomes you get to interact with the client a lot more, and it's less just mindlessly scrolling or looking through paper files. And I would argue that in a lot of these situations where data, like, for instance, the landlord-tenant situation, where there's these databases of tenants who unfairly are in this database because, the reason they didn't pay is because their refrigerator wasn't working and they've asked their landlord, and that case shouldn't be in that database. But I would argue that the answer isn't to stop open data. The answer is to put more restrictions on landlords from filing these kind of frivolous suits. If you introduced more policies that penalized landlords, for just filing at the drop of a hat instead of when it's actually warranted, I think that would cut down on a lot of these kind of frivolous lawsuits. And then, when it comes to whether or not any tenants belong in any kind of database, there is the flip side that if a tenant purposefully doesn't pay, is just trying to get away with free rent, then maybe those tenants do belong in a database because they are purposely trying to not pay rent. And so I think this is less of an open data issue and more of a fixing some of the court rules around landlord-tenant issues. And I want to talk quickly about algorithms as well. And I think the biggest problem with algorithms right now is that they're really easy to make and really hard to get right. And they're also really easy to pitch to groups that want to, have cool, sophisticated technology to speed up the processes. I think this will, in time, get better and better as people become better at algorithms. We learn from our mistakes. But there is a benefit from having some of these algorithms, especially in the court context, whether it be risk assessment for bail or risk assessment at sentencing, is it provides a structured review process where, I'll put in quotes objective, because I know there's lots of reasons that you might not consider it objective, but you can actually see what an objective computer has determined is the risk of a particular defendant. And you can argue if the judge goes against that, the judge will have to put that in writing. And so you can get away from some of these where the judge just hands down a very large sentence or a very easy sentence. And there's just kind of no rhyme or reason to it. You don't really have any kind of avenue to say, well, why did the judge really think this way? Was that the right way? If they have to go against what this structured system is telling them, and they have to put that in writing, I think you're going to get away from some of these biases that all judges have. And while all of these algorithms, I think, have some bias in them, certainly, because a lot of them are based on criminal data, and all that criminal data has a lot of bias built into it from the past. I would argue it's a lot easier to change an algorithm than it is to change the minds of hundreds and hundreds of judges through whatever kind of trainings you want. So, for instance, if you run the algorithm and you find that it is being biased in a certain percentage against a certain race or group of people, you can then tweak that so that you can try to make the algorithm more fair. And that takes a lot less time than it does to try to train judges on bias training. And so while there are certainly issues to work out with algorithms, I think ultimately we can get to a much more fairer system than we can if we just scrap algorithms entirely.
Well, with that provocative statement, I'd love to throw it back to Michelle and Natalian to get your reactions to the question: is it easier to change bias in our algorithms than it is to change bias in our larger legal structures? I'd love to hear your thoughts on that, and then perhaps we can turn to some of the excellent questions that are being posed by some of the viewers of the webinar. But I'd love your reactions to that proposal.
I mean, I would respectfully disagree because the algorithms are made by people. They're not Cabbage Patch dolls. Like, we don't just find them in the garden. And we can see this in industry. So many of us that work at the intersection of racial justice and technology are really reeling from the firings of Timnit Gebru, Michelle Mitchell at Google, and then across at Pinterest, colleagues there. And what we found in those firings, these were, at least in the Google examples, computer scientists that were really looking deeply at this question of how can we create algorithms that don't show bias. And in order to do that, we would have to revolutionize the way that we build our software systems. So for those who don't know, typically when we're building a software system, for the sake of argument, I'm going to take a bail predictive algorithm. What we would do is that we would look at every single bail determination made for the case of this conversation throughout history. The algorithm would then pick up patterns in those determinations, create a statistical model, and that model would then become the North Star. So if you have a criminal system that for the last 100 years, for reasons of racism, right? Reasons of racism and anti-poverty in this country have put poor people and people of color in jail. And we don't know what those circumstances were. We don't know whether they were just. Even the idea of a database for people who don't want to pay rent, even that really scares me, because typically people just want to live dignified lives. They want to be able to pay their rent. They want to be able to have decent food. They want to be able to send their families to school. And so this idea that there's this nefarious, bad non-rent payers, I'm not saying it doesn't exist, but what if you slip into that category or seemingly slip into that category? Who's making that determination? Once you put those in and then you develop this statistical model, your algorithm also picks up all of that bias. So what I would argue is, rather than, again, coming from a justice framework where we're quite happy to rethink and reimagine new laws, rather than trying to tinker around the sides and make the bad algorithms do good things, which I think you do remarkably with your work in Maryland, why can't we do some of the speculative thinking that's being done in industry around how can we design these systems better with equity in mind, or how can we optimize them for equity? So rather than picking up the sentences of everybody that's been arrested, Ruha Benjamin in her book says, well, why don't we look at the people who are not arrested? Why don't we look at Wall Street traders? Why don't we look at white collar criminals and try and pick up when they weren't arrested, figure out why these people aren't arrested, and then pay closer criminal attention to them. And so I like the thought, but I just think we're people and that we're imperfect, and that shows through in the work that we do as creators, including creators of technology.
Thank you for that. Michelle, let me hand it over to you. Matt, you'll get a brief rebuttal, and then we'll move to questions from the audience.
Yeah, I really agree with everything that Mutale said, and I'll add a few additional reflections. No matter how you program an algorithm, there are certain things algorithms are not going to be able to do that we rely on humans to do. And as lawyers, we're very aware of this, because so much of what happens in a courtroom every day is about a decision maker assessing people's credibility. Who do you believe when there are two conflicting stories? It's about exercising discretion under legal standards that require decision makers to balance factors or consider the totality of the circumstances. And these sort of nuanced exercises of human judgment are not just in the courtroom, they're throughout society. So even if we improve and are able to debias algorithms, which is questionable, as Mutale points out, we still need what a lot of people in this field called a human in the loop. If you think you're just going to get rid of people and it's going to be cheaper and more cost effective to go to the computer, it looks more objective, it looks more neutral. I don't believe that reality can be true, because the need for human judgment still exists. And remember, if a human decision maker makes a mistake, it affects, unfortunately, the person before them. If an algorithm makes a mistake, the scale and the speed of these tools can impact so many people so profoundly. So that's one observation. And then my other observation is that we can't assume that a given technology affects everyone the same way, regardless of what sort of biases are baked in or baked out. So one example is facial recognition technology that Natali has talked about so eloquently. Landlords are increasingly interested in using that in lieu of having residents use keys. Okay, so for residents of a high income, affluent development, that may have a gee whiz factor. They love tech, innovation, new tech toys and tools, and it may be very desirable. The exact same tool in a low income housing development may be extremely upsetting to those tenants. And we've seen this play out in some housing developments in America already, where people feel stigmatized by that. They feel like their home is being turned into a prison. They worry about that data being fed to law enforcement with, arrests and harsh consequences down the line. So you can have the same technology with the same sort of data and analytics, and it impacts different populations quite differently. So I think the conversation has to be much more about like cleaning up the data and debiasing and thinking about these tools in the social context that they exist in and how they impact people's lives day to day.
Thank you. So Matthew, how about briefly responding to judgment and context, and then we'll turn to some questions from our audience.
Yeah, so first I'll talk about what I agree with both of you on. I definitely don't think, especially at this stage of legal tech, that we should remove the human element. I think all of these algorithm technologies should always have a human that makes the ultimate final decision. And that's how all these court algorithms are currently used. They're supportive, but if a judge looks at the facts and says, okay, this is totally out of whack, the algorithm might be wrong or the facts say otherwise, and they can override the algorithm, which I think is completely justified. What I would say is we shouldn't let perfection be the enemy of the good. The standard or the goal should not be to immediately create an algorithm that's 100% correct. If we create an algorithm that does some kind of risk assessment and we study it, I think all of this stuff should be open to being studied. And it turns out that the algorithm is less biased than what came before it, just regular judges with their own decisions. That is a step in the right direction. We shouldn't just abandon algorithm and go back, because the alternative is going backwards. And so, well, certainly you want to create an end product that doesn't have any bias. It, in all likelihood, will be a slow, gradual progression. Now, we shouldn't just implement an algorithm and then throw up our hands and say, okay, it's in, let's move on to the next thing. It needs to be constantly studied, constantly updated. And just briefly, when it comes to the landlord-tenant kind of situation, we could ban all databases that include any kind of tenants. But landlords aren't just going to kind of give up the fight and say, well, I guess we just won't ever know. What it's going to do is it's just going to drive it to kind of seedier options. There's going to be listservs or lists that landlords just throw tenants on because landlords don't want to rent to risky tenants or tenants they deem to be risky. And so if we have an open data and we fix some of the court filing restrictions, we can at least limit and have an idea of what tenants would be added to this kind of database. If we just try to close our eyes to it, we're just going to create this kind of black market where we have no idea what tenants are there. We have no way of challenging it. We have no, it could just be landlords throwing people on there for any number of reasons. So, I don't think we can just stop the idea of putting any kind of failure to pay rent cases online. It's just going to drive it to another area.
It's almost like an analogy to prostitution or drugs. It's inevitable, and maybe we need to keep it out in the open and monitor it and legislate around it rather than drive it underground. Interesting and provocative discussion. Let's turn to some questions from our audience. Stephen Waddy has asked he's asked three questions, but I'm going to group two of them together. One of them asks, how should the American educational system system train middle schoolers and teenagers on the ethical uses of technology? And another one also related to school is, are school systems adopting these same algorithms and facial recognition technologies to profile young people? So I thought, let's talk about young people and education. I'll open it up to whoever would like to jump right in.
So the New York Civil Liberties Union recently pushed through a ban of facial recognition use in schools in New York State, and it was being used to try and recognize when kids were paying attention. So by using the technology, the idea was that you could look at the emotion on a child's face, and I don't know what you do with that. I think what was missed was the way that we emote is deeply cultural. At the beginning of my career, I lived in Japan, and which is all about the face, and if you look directly at somebody, that was considered extremely rude. But going back to the UK or the US, in a professional setting, if you don't look at somebody directly, that's also considered extremely rude. And so it didn't allow for that nuance, which is going back to this keeping the human in the loop. There is actually an advocacy organization called Encoded Justice, which has been put together by it's a national organization put together by a group of teenagers after the death of George Floyd. And what they do is that they partner with school districts across the country, and they speak to, I think it starts at 6th grade, which would be certainly middle school in New York State, and start to speak to kids about technology generally, but this idea of power and peril. And so I'm excited to see what Gen Z will do, because these are also the kids that went on TikTok and got all the Donald Trump tickets for the rally and then didn't show up. So I'm really interested to see how those discussions happen, how the kids react. They actually have a legislative town hall coming up, because AI for the People and Encoded Justice were two groups that testified in front of Minneapolis City Council just before they passed their ban on police use of facial recognition last month. I don't know if that answers the question.
It certainly provides vital context if it doesn't answer it directly. Michelle or Matt, would you like to contribute anything to the educational question?
Yeah, so just real quick, I think one of the big things that we should teach people, especially students, because almost every student now that's in middle school or high school now, their job is going to revolve around technology when they finally enter the workforce. And I think the big thing is to explain to them that data is not just kind of perfect. That especially like in the criminal data context, that there is a lot of backstory to how that data got here, what's missed, what's overrepresented. And I think it's important from an early age to instill that you can't just rely on this data just wholeheartedly. You need to really analyze it. Can you add in other data? Can you make sure and do whatever you can to make it as fair as possible? So that's just my 2 cents there on education.
The importance of data literacy. Michelle?
Yeah, the only thing I will add, I love these ideas about educating kids and also the grassroots element of kids taking the autonomy to educate and empower themselves. Children in schools live under tremendous surveillance, and it goes far beyond facial recognition technology and cameras. Their school systems, in the name of keeping kids safe, have adopted not just cameras, microphones, law enforcement presence. Their social media is scoured for certain words that might indicate future dangerousness. Their assignments are algorithmically analyzed in a similar way. They are being proctored electronically now in the Zoom era by software when they take exams. And I'm not even like doing a full description to the way that kids are surveyed. And the thing that really concerns me working with low income communities is that this is generating evidence that is feeding the school to prison pipeline. And more often than not, the things that kids say and the way they act online are developmentally appropriate, but then misunderstood and misused by school systems and court. So I'm so glad that an audience member raised the concern about how we're surveilling kids in schools, because it is extremely important and consequential.
Thank you all for that. I'm going to turn to another question. Lisa Blitzstein asks she says, as far as I know, the Facial Recognition and Biometric Technology Moratorium Act has been sitting in the Senate since last June. To Ms. Conde's point about lack of action at the federal level, one, would this legislation be a good start towards addressing equity considerations in biometric tech? And two, how much farther would it need to go?
I don't know that statute, but I was involved in the drafting of the Algorithmic Accountability Act. And that was, even though that was introduced June 2019, we were drafting for 2 years. So if we go back to 2017, we had Trump in the White House, McConnell presiding over the Senate, and Paul Ryan, if anybody remembers, at the House. So we entered what's called a messaging bill. And what that means is that we just want people to talk about it. But our major ask within that bill was for the development of an FDA type agency that would look at impact assessments. So this idea that you can't just design an algorithm in your garage on Sunday and then Monday it's released, you gather data, and then you're scaling on Friday, right? And which is really, I'm not being facetious. Many of the products that we use were really introduced into the marketplace in that way. Google specifically, that is their origin story. And so what we were hoping there was that people would realize that anything that we put in our mouths, we are now living in COVID times where talk of trials and clinical trials and accuracy are part of our everyday vernacular. But back in 2017, people really weren't thinking in those terms, and it didn't go anywhere, and it really wasn't designed to go anywhere. Where it did go was to the New York Times, where it did go was to Wired and all of these other publications, and it generated a conversation so that people would understand what an algorithm is. Professor Gillum and I are both alumni of Data and Society, and I was going to DC with my colleagues from Data and Society, and I remember the very first briefing that we did for the House Progressive Caucus was called "What is an Algorithm?" And we sat with a room of around 25 senior staffers and some lawmakers, and they were like, "Algo, what? What is this thing? What is a machine? And the machine tells you what to do?" And we were like, yeah, not only does it tell you what to do, you could get thrown out of your house or into prison or out the country or, not given citizenship. I became a naturalized citizen last year and had to my face was scanned through a facial recognition unit. And when I looked at the paper, it said 93% inaccurate. So I have no idea who the citizen is. I just hope that ICE doesn't come after me. But this was the case. So in terms of what could go further, that act and the one that you're referencing didn't have any type of enforcement strategy, and that's because they were not meant to be enforced. So what we would need to think about is what happens when companies don't follow this. And it can't be a $5 billion fine like the FTC passed a couple of years ago, because these companies are making $5 billion a day. It has to be, I was on a panel and I was really mad about that FTC fine. And they were like, well, what would it have to be? And I said, it would have to be what they made last year times 10. It would have to be a really devastating number that would shut them down. But beyond that, we also need to start thinking, what's a public utility? Should internet access even be in private hands at this point, if we have to go to school using the internet? And so I think, again, just really pushing on this idea of justice, rethinking our markets and rethinking what we need. And lastly, Lina Khan is at Columbia Law School and has written a huge amount on antitrust. And really, part of in the antitrust community, along with Tim Wu, who I believe is going to the White House, they're really thinking about, well, do we need to change the market structure so that being a good technology can be as marketable as some of the more nefarious products we see on the line in the market?
One thing I'd really like to see in terms of law reform and lawmaking is a shift away from the current model where we each have individual responsibility for protecting our own data, right? So every time you open a new website or an app, a privacy policy appears that I guarantee you don't read. And if you did read it, you have no opportunity to negotiate it. And you click, I agree, as a term of using that service, and all your data is scraped and sold and used. And I would like to have some laws put in place that shift more of the onus for protecting personal data on the companies and government agencies that benefit from it. Right now, it's very lopsided, it's very one-sided. And so we really need much more shared responsibility, if not just much more responsibility on the entities that benefit from our data.
I just have two cents on that real quick. I take more of a libertarian approach to laws on technology. I mean, we all remember, the Congress hearings when they talked to Facebook and Microsoft and Apple, and it was clear that a lot of the legislators just had no idea how technology worked. And we can look back at different statutes like the Computer Fraud and Abuse Act, which is just extremely hard to understand. It seems to both allow and criminalize all computer activity. And so I'm very weary of putting in the kind of the fate of legal tech, especially, but data in general, in the hands of people who I don't think truly understand exactly how it works, and to legislate it properly. And especially given the climate today, once a bill gets passed, it's never going to get changed. It's going to take years and years and years. And despite all the flaws that groups like Facebook or Microsoft or Google might have, the great thing is that they're all American companies. If we start to regulate this, where it just becomes impossible to use data and it becomes so expensive, and we start finding companies out of existence, companies outside of America are going to be the ones that wind up becoming the next big Facebook, Microsoft, and Google, and then we'll have very little control over what they do. So I don't want to push too far in that direction. I'd rather push and fix some of the things around things that Congress has, or the state has experience regulating, like maybe things relating to court filings and stuff like that, rather than data and technology itself.
Excellent. So I think we've actually tangentially addressed Michael Hagan's question, which was asking about corporate policies. And I think the point that he raises, and all of you have discussed to some degree, is really important, that this isn't just about the government. A lot of what's going on, a lot of what we have to be concerned about is within the private market and private markets. And we've of course heard different perspectives from you on how to address that. Before we're coming up towards the end of our time together, and so I want to ask a closing question. I do want to say, Mutali, I'm glad to hear that you're a naturalized citizen. I hope you always say garage instead of garage, because it's much, much better. But the final question that I'd like to have you guys consider is more looking forward, right? It's what can all of you, although describing some pessimism, all of you are technologists. You're not Luddites. You're not scared of this. It's about how do we craft the right way forward. And so the question that I want to ask each of you is, what does algorithmic justice mean to you? What kind of systems do we have to put in place? Are the current way that we look at things, the current frameworks, is it sufficient, or does something need to change in order to achieve algorithmic justice? So we can go in any order, but may as well go in the order we've been going in. Michelle, I'll ask you first.
Yeah, when I think in terms of algorithmic justice, there are certain baselines we need to have around technology. We need to have the transparency. We talked about that already, giving the public access to understanding how algorithms work. We need accountability. We need entities to be accountable when algorithms go wrong, when they're unfair, when they're biased. And we need algorithms that are fair. And several folks in the Q&A talked about this idea of fairness. But thinking more broadly to even justice, what I would like to see are these different data-centric technologies designed and used with stakeholder input, right? So we're not just acted upon, we become actors in these systems. And overall, I think they should be tools that empower people rather than oppress them. That's as simple as I can say it. It should be used for empowerment and opportunity rather than subordination and oppression.
Mutali, thank you, Michelle.
I would completely agree. The only thing that, and it's not really adding, but the only thing that I would push into is really igniting this idea in the collective imagination that we are now technical citizens, right? I think that the work of AI for the people, and the reason that we'll use film and television and music and social media to communicate with our publics, is that we want people, specifically Black and brown people and poor people, to realize that part of being a citizen is also understanding how government works. And the reason that we're really interested in government is that we don't want to get into the business of legislating private behavior and taking away choice. But we do want you to know that if you didn't get that apartment or perhaps that job, or you were picked up in a virtual lineup, the systems that helped in some cases, and I would argue made the decision in other cases, as we're seeing in arrests, were these algorithmic actors. And so I always tell my team that we are definitely daughters of Stacey Abrams, in the sense that we are interested in going into communities, finding out what those communities need and want, and then arming them with the information so algorithmic justice becomes something that they think about alongside voter rights, alongside right to clean air, clean water, and the other important things that we all need. And we're coming close to time, so I'm gonna pass to you, Matthew.
Thank you. So going forward, I think the biggest thing we need to do to make sure that these new legal tech tools are used for good and not for evil is that we need to study them, and we need to go in with the understanding that these tools are not a silver bullet. There's no algorithm that's going to be perfect right out the bat that's going to solve all of your, fill in the blank. So we need to have that understanding. We need to be rigorous about how we study it to make sure we're not doing more harm than good. And usually that's a very diced up question. You might be doing good in one area and bad in another. And we need to recognize that and make sure that we improve upon it. But the benefits of these technologies allow for potentially is massive. And so I'm very weary of trying to restrict them to the point where we don't see that come to fruition. We're seeing a lot of the negatives right now. And so it's kind of hard to see just how big some of the positives may be. But we're there, and we shouldn't try to kind of squash them right now.
Well, thank you, Matthew. Thank you, Mutali, and thank you, Michelle. And thank you, everyone, for being part of this discussion. I think that the call to studying it closer with an eye towards understanding justice is one that we can all agree on. And I think this has been a wonderful discussion. I'd like to point something out that Chris Stutz put in the chat. If there's a lot of wonderful links that our panelists have put into the chat, if you are interested in getting a copy of that, you can email Chris Stutz at cstutz@ubalt.edu, and she'll send you a copy of the chat that has all the links in it. But with that, I think we'll call the evening to an end. Thank you again to everyone. And don't forget that next April 14th, there's the School to Prison Pipeline webinar as part of this ongoing series. So we'll leave it at that. Thanks, everyone.